lovely professional university. And I welcome you all to the 11th seminar of E-Legal Festival Edition, organized by student organization Democrats under the Aegis of Division of Student Affairs, lovely professional university. Our special guest for today is Dr. Rupam Jagota. Dr. Rupam Jagota is a senior assistant professor from the Department of Laws, GNDU, Jalandhar. Dr. Jagota is a PhD in law and specializes in criminal law, jurisprudence, constitution, and gender laws. Dr. Jagota is also a member of the DLSA, is also associated with mediation and conciliation and call providing redressal mechanism. I call upon Dr. Rupam Jagota to start with the topic of fundamental rights.
A very good afternoon to all of you. Am I audible to everybody?
Yes, ma'am, you're audible. Good afternoon, ma'am.
All right. A very good afternoon to all of you. Right. Now, when we talk about the concept of fundamental rights, first of all, before I come down to the topic, I'm very thankful to the Student Council, Abhishek Grover, for giving me the invitation on behalf of the LPU. To have a discourse with you today on the topic of fundamental rights. The topic is very, very relevant and appreciable in the context of the growing demand of the society, where we are asking for fulfillment of our legal rights. And if you look back from 2017 to the current situation of 2020, living under COVID-19 and surviving those conditions, the concept of rights, responsibilities, and duties has gained a lot of momentum. So, looking from the perspective of fundamental rights, we focus on the framework of the Constitution. So, if you analyze very minutely the constitutional framework, we see that fundamental rights have been envisaged under Part 3 of the Indian Constitution, and the focus on the fundamental rights are the what could be enlisted by, I think, the world community looks upon the Indian Constitution, the way we have centralized these rights as the fundamental rights, and they are accepted all over the world. Nations look up to us upon the framework which we have imbibed, because we have the written lengthiest constitution of the world. So when I look upon fundamental rights, Article 2012 to Article 35 is devoted to the concept of fundamental rights. We classify the fundamental rights into 6 broad categories. First is right to equality. Article 14 to 18 is focusing on the concept of equality, which we can further diversify. I'll go into that, but first help us broadly cover what are the 6 categories of rights which we are having. Then right to freedom, right against exploitation, uh, freedom of religion, cultural and educational rights, and then we have the right to constitutional remedies. Under the ideology of fundamental rights, only laying down the fundamental rights in the Constitution is not important. What is more, the prerogative is how these rights are to be enforced. What is the enforcement machinery so that redressal is available to the people if their basic fundamental rights are violated, either by the state or encroachment has been done, or they have been restricted or restrained from enjoyment of the fundamental rights. So we have vested the judiciary, or we have armed the judiciary with the power, that is, it is capacitated to issue writs. There are 4 kinds of writs which can be issued by the judiciary whenever there is a violation of the fundamental rights. Writ of habeas corpus, writ of mandamus, writ of certiorari, writ of prohibition. So judiciary has been sincerely, dedicatedly working upon to ensure the enforcement of the fundamental rights of the people. So our focus has been to ensure that these rights are protected at all points of time. Even during the state of emergency, Reasonable restrictions can be imposed on the enjoyment of the fundamental rights, but we do not make the rights absolutely dead. So rights are available to the people at large. Now, when we look upon Article 14, earlier we used to have right to property also on the statute book, but by the 44th Amendment to the Constitution, it was taken off the list of the fundamental rights. Now, Article 14 to the Constitution emphasizes on right to equality. So, if we analyze the concept of 14, Article 14 to the Constitution, it says that state shall not deny to any person equality before law and equal protection of the law within the territory of India. Now, if I bifurcate equality into two parts, it is equality before law and equal protection of the law. So, when equality before law, it means it is prohibition of discrimination of any form and kind. Everybody is subjected to an equal treatment before the law. Equal protection will be available to all people. Special treatment can be given to persons in different situations in order to establish equality among them. We already lay down the provision that special treatment or special reservation can be created for people belonging to scheduled caste, scheduled tribe, and other backward classes. So that is within the permissibility of the concept of right to equality. The framework of the Constitution also emphasizes that a reasonable classification is permissible when we talk about right to equality. Focus is that equals must be treated equally. So the Constitution is in favor of ensuring that there must be equality of treatment to all persons who are the citizens of the country. It is also redressable to the non-citizens of the country. Idea is that discrimination cannot be carried on, which is against the fundamental concept of the Constitution. Then right to equality